door, so do we want to not limit it or limit it?
I mean, it's kind of hard because I also since we only have one shuttle today, we're going to have a lot of big people. Yeah, I'll put in eight. No, it's not. It actually says
So there's one shuttle.
Yeah, there you go.
you guys are
Yeah.
Are you recording already? I think they're
I didn't know there
literally
was a shuttle.
they're literally still coming here. Just 1 minute.
I signed it.
So do you need All right, everyone. It's about 12:17, so I'm just going to get started. Just to give everyone a heads up, we have about 12 cases we'll be presenting on today in about 60 minutes. So it's about a little less than 5 minutes per case. If any of you have questions, it may be helpful to just save them for the end. Unless they're super important, then of course you can ask them. But just so we can get through all the cases, it may be better to just hold off and ask one of us afterwards. To start, there are 7 cases we will not actually really be presenting on. The first 5 are APOA cases that Jessica Jorgensen presented on in November and December. If you have any questions, you can come to us afterwards about them or ask Jessica. There's 2 other sort of dependency-related cases that were published the last 6 months. One was Bianca M versus Superior Court. That case is really about immigration court. The cases that were, or the statutes that were cited in that case don't really directly apply to us. The main one being the Uniform Parentage Act. But that case was basically about whether or not a father had a right to be present at the immigration court placement hearing, even though he did have notice. But none of the laws, again, apply to dependency specifically. The other one is Enrage MW. That one was regarding a 19-year-old non-minor dependent who was appealing an order from the juvenile court saying that a former foster home would not qualify as a SILP placement. We generally ask to be relieved by the time a kid turns 18 and becomes a non-minor dependent, so unless you plan on being a CLC someday, this doesn't really apply. So our first case is Enrage EB. There's a lot of procedural history in this case, so I'll try to get through it as quickly as possible. Basically what happened was the department filed sexual abuse allegations against the father, and the father was non-offending. The minor was placed with him. He previously had overnight visits due to a existing family law order. There was a lot of family law history in this case prior to that, but he was non-offending in this D count petition. After that, after a full trial in which the minor described the perpetrator's penis and actually drew a picture of it, Wazer dismissed the case saying that there was a picture of the perpetrator that was admitted into evidence. Wazer said that the perpetrator could not have the penis that was drawn by the minor and dismissed the petition in its entirety. Now, Wazer proceeded to disposition over my objections. Oh yeah, one caveat, this is my case, which is why I know so much about the procedural history. But he proceeded to disposition. I objected, saying, well, you can't proceed to disposition if you dismiss the case in its entirety. And what he did after that was he removed from the father, placed with the mother, and he said the father's visits had to be monitored in a therapeutic setting. So they went from non-offending custody to visits in a therapeutic setting, extremely offending. Fast forward to the contested dispo hearing. Wazer reclassifies the hearing on the record as jurisdiction, even though he had previously said the next hearing is going to be disposition, and the calendar said it was a disposition hearing. Of course, I objected, and he got really mad at me. But it was true. I mean, it was a disposition hearing. He had went forward with some bogus, contrived allegation that he had made up on the spot and called this a dispo. So after that, after I corrected him, he continued the jurisdiction hearing and formally filed his own new petition with A, B, and C counts against the father for emotional abuse, saying that the whole sexual abuse petition was a result of family law issues regarding custody. Neither minor nor DCFS agreed with Wazer, and the mother's counsel, who was Karen Green Rose, was largely silent on this issue. After that, we went through a full trial again with the same witnesses, this time with the minor's therapist testifying as well, who testified that the emotional abuse wasn't severe emotional abuse or severe anxiety, which is required under a C count. I also objected to Wazer violating due process by basically no longer just calling balls and strikes, but going forward as a moving party and being the fact finder for the petition that he had introduced to court, which made no sense. Minor and DCFS argued for the dismissal of this new petition as well. Wazer only sustains the C count. I appealed. The ruling on this in this hearing was that the discretion to file a 300 petition belongs to the social worker, not the court. That's what WIC section 325 pretty plainly says, as well as the corresponding rule of court. After dismissing the petition, juvenile court should have returned the child to the parent's custody under the prior family law orders. Juvenile court violated the father's due process right to a fair trial when it brought in adjudicated allegations based on factual and legal theory not raised before and actually opposed by DCFS. Pretty straightforward. I think everyone here knows that the court can't just bring its own petition. That would be a violation of due process. The distinction is in Enrage C. The court is allowed to conform or amend language to proof as long as the amendment is consistent with the theory of the case or the issues in the case that were brought up in the original trial. If anybody cares, Enrage C is 93 Cal App 4th 1027. And we see courts amend or conform to proof all the time. The next case is SV versus Superior Court. This is regarding WIC 361.5B3. Basically, whether prior physical abuse to a minor or sibling that led to a removal and then reunification with that minor applies to siblings, which it plainly does. If you look at 361.5B3, the plain language says it's not just that a minor is removed, a minor has physical abuse allegations and is removed, and then it's the same minor. It could be the minor's sibling as well. In this case, what happened was a mother reunified with a child in a physical abuse case, and then after reunification, 2 months later, another petition was filed on the child's half-siblings for physical abuse again. About a month or two after that, the San Bernardino County HSA filed another 300 petition with J counts for the original minor who had been removed. So the Court of Appeal said that obviously 361.5B3 applies. Didn't really move the needle that much for the original prong of bypass. The second prong of bypass is in subdivision C2, whether or not it was in the child's best interest to give that far. Obviously that's our burden. Where this case might have moved the needle a little bit was that It found that the evidence supported the finding that it was not in the child's best interest to give FR because just a couple months before a new petition was filed, mother had gone through a case plan and then reunified. But basically, the fact of the matter, it's like a res ipso facto kind of thing. The fact of the matter that B3 applies means that it's also not in the best interest, which is kind of a tough ruling for us. But it's important to remember or to distinguish from any cases that you might have when this bypass provision applies. In this case, the original child suffered a second-degree burn on his foot, a fractured skull, and a broken leg. So the physical abuse was really severe. And this court also found that B6 applied as well. B6 is about severe physical or sexual harm to a minor or sibling, and the court finds that bypass is applicable because FR would not benefit the minor. So there were two provisions actually, and that's how you can distinguish from this case. The next case is another Wazer case, Enrage DY. This is a case in which legal guardianship was the permanent plan after a couple of years of FR, and then kept open for a total of 16 years. At the final hearing, Wazer denied a continuance request from DCFS to provide a supplemental report regarding educational and orthodontia issues, which were important in this specific case. And the initial report from the department said that another report would be forthcoming. Wazer also denied a request from Minors Counsel for a contested hearing for maternal grandmother and minor to be present. Again, this might be a case that doesn't really apply to us strongly because after 16 years of RPPs, most of us would probably ask to be relieved, or we should probably ask to be relieved if the parent doesn't show up. Under WIC 366.3a, the juvenile court is not required to retain jurisdiction just because a guardian objects. However, it was an abuse of discretion to deny what was a good cause continuance for two reasons. Number one, the report wasn't complete with information that the court needed in order to JT. And second, this is pretty big, neither the child or the grandmother, the caregiver, had any notice that the case would JT, which was important because the case had been open for 16 years. Imagine if, you have a case where you expect to keep coming back, then all of a sudden with no notice it just JTs. The weird thing about this case is that just 2 hearings before this, Wazer, the department actually asked that the case close. Wazer disagreed and said, no, we must keep this case open, but apparently he forgot what he had said just before this. I know, I'm fast. Okay, the next case is Enrage Bruno M. This is regarding including children on permanent restraining orders. Before we go into the ruling, it's important to look at the facts so that you can distinguish whenever you have a case where there might be a contest regarding whether the children should be added to a restraining order. So this case involves a 5-year-old and 2-year-old who were frequently present to witness domestic violence between the mother and father. On one occasion, mother was knocked unconscious and woke up with the 5-year-old next to her, who told her, quote, "I thought you were dead, Mommy. Why didn't you make my daddy happy so he won't hit you?" On another occasion, he threatened his mom, saying, "If you don't let me play with my toys, I'll hit you like my dad." The 5-year-old reported being scared from the domestic violence, actually yelled at his father to stop on one occasion. The 2-year-old, who was also present at one of the DV altercations, actually was covering her ears while it was going on. Later on, the 5-year-old mimicked his father, hitting his mom by hitting his younger sister. So the ruling is that the evidence supported including the children in the permanent restraining order because they had disturbed the peace of the children. That language, disturbing the peace of the children, is in WIC section 213.5. The other reasoning they use, that they were in the line of fire, is not in the section, but there is a lot of case law that uses that terminology. The Court of Appeal also ruled that it was reasonable to infer that the restraining order was necessary to protect the children in the restraining order because mother had a tendency to return to the father after deviant altercations, and the father had repeatedly threatened to, legally speaking, kidnap the children, which is why they should have been in the restraining order as well. Really bad facts here, so I think it's easy to distinguish from whatever case that you might have in front of you. Again, these types of cases are very fact specific, so hopefully the distinctions help you more than the actual rule.
Hello, I'm Shannon, and it is UCCJEA time. Yay! So, let's get started with RB. I have 2 UCCJEA cases for you, and I know that over the last few months, some of us have visited and powwowed about UCCJEA. So, our first case is directly from the family court. The second case is going to be a dependency court case. So RBVBR is it's actually a family law case. And basically, these 2 parents, they are from India, okay? Now, for purposes of UCCJEA, just so that in case you ever get a foreign case, over the course of my dependency career, I have had a handful of cases that were from other countries, not just from a state, an American state. And so for purposes of UCCJEA, foreign countries are treated as states for purposes of that statute, and that's in 3405 subdivision A, family code section. So these 2 parents are from India. They were married in India. They moved from, having been married in India, they moved from India to California and had their child in California. So this child is a toddler, no more than maybe 2 or 3 years old at the time all of this, the DV is going down between the parents. Now, getting into the facts, because as some of you who have handled UCCJEA issues know, the timeline is very important, and those of you who have worked with me, you know that my UCCJEA Writ, and when I've researched it, they are time and fact intensive. So I do want to advise you as my colleagues, I think some of the biggest mistake that I'm seeing is that even experienced attorneys don't take the time when we are rushing around in court and we're trying to satisfy our bench officer. They want you to do that detention and get it done. Hey, how many times have we gotten that phone call? We got a parent in New York, we've got a parent in Virginia, we've got a parent in Texas, Mississippi, Alabama, or whatever. I need you to get on the phone and talk to them and fill out that paperwork right now. And there was a writ that I handled a few months ago where that did happen, and we completely overlooked the potential UCCJEA issue there. So here we have these 2 parents who are actually married in India. They live in California. They have their child in California. But in the 6 months prior to the commencement of the proceedings, which is 6 months before the petition is filed, the child should, for the most part, reside in California. For the most part, and that's me trying to put my, layman's definition to it. But for 6 months before the petition is filed, they should be residing primarily in California. These 2 Indian parents were back and forth between India and California a lot with this 3-year-old child. Their home was here. Grandparents and relatives were back in India, okay? So, of course, while they're on a trip to India, dad hits mom, dad and mom get into a brouhaha and into a fight. And dad asked the child, who do you want to be with, me or your mom? And dad says, I want to be with mommy only. Dad smacks the kid. This is in India. So mom and the kid return to California. Dad goes on a trip to Florida, I guess, to see his side chick. So, and then they get into some phone disputes, and dad's like, get out of my house in California, okay? And then mom takes the kid, returns to India with the child, okay? So you've got 3 different states, dad's in Florida, mom's at the house in California, grandparents and family, and the DV incident took place in India. California was found to have exclusive home state jurisdiction. There is no concurrent jurisdiction anymore. Only one state can have exclusive jurisdiction. Under old law, yes, concurrent jurisdiction, 2 states could have it, okay? But now under UCCJEA, there can only be 1. However, there is a such thing as inconvenient forum. You know, you probably haven't heard of that since, you know, 2nd year law school, Civ Pro, whatever. But under 3427 of the Family Code, there is inconvenient forum, and there's a specific set of factors that have been outlined in Family Code section 3427 that a California court should take into consideration when deciding whether or not a family is whether the case should be heard here in our court, okay? And so under 3427B1, what's the first thing that is listed in 3427 subdivision B section 1? If domestic violence has occurred. Did it occur here? Did it occur there? If it occurred in another state and it didn't occur here, then the court in this state will consider that. And if you are arguing at a detention, UCCJEA and jurisdiction and home state jurisdiction should not be your only argument. If there is domestic violence involved in the case and parents and mom is saying he was beating me up and he beat me up when we were back at home, then you should be considering whether to argue before our judge whether or not this is an inconvenient forum because domestic violence happened back home. Are the witnesses back home? Is the evidence back home? That's what 3427 subdivision B lists. Is the child here, or is the child somewhere else, or is the child from somewhere else? If a 3-year-old child has been here for a couple of weeks, but grandma and the child has been staying with grandma for the last couple of years, and grandma is the one changing that kid's diapers. Grandma is the one breaking up fights between the parents. Grandma knows everything, sees everything, has a social security card. Grandma is the real mom and she's in Alabama. Then maybe you need to go outside and make a quick phone call for 5 minutes like I used to do in court and say, hey, grandma, you know, what do you know? And that's more information that helps you argue to our judge that the case should not properly be here. The evidence might be there, the witnesses might be there, testimony could be taken there. Alabama or whatever state or another country might be the appropriate forum. And so here, even though the parents had the child here, the child was an American citizen, the home was here, and they had established a residence here, primarily for purposes of 3427 subdivision B, and also financial hardship of litigating here versus there. That's also another factor to be considered under 3427, the distance between this court and another state. Emily, you've got your hand up.
I didn't mean to interrupt, but can California decline to exercise jurisdiction if another state's more convenient, if the court in the other state is either not responding?
Absolutely.
Or the case?
That's where we're headed with the next case.
Okay.
Yes, no, absolutely. So here, just keep in mind, instead of just keeping your argument at whether or not this is the state where the child resided and whether California home state jurisdiction, also be considering whether, even if California does have home state jurisdiction, are we the appropriate forum? Where's the evidence? Where are the witnesses? If there's drugs involved or whatever, or if there's domestic violence, then should you be making an argument pursuant to Family Code section 3427 of inconvenient forum? And all those, there are 8 factors that are listed there under subdivision B that you should be considering and tossing out there in your detention argument if you are dealing with parents from a different state. Okay. I hope you don't mind, but can I jump to the next one and then back to Israel T, since I'm already on UCCJE and answer Emily's question? Okay, so let's skip over Israel T and go to ER. Enrage ER, guess what? Dependency mom. So, you know how we always joke about mom should just go have her baby in another state if she's already lost like 4 or 5 kids here? This lady tried that. didn't work out for her. So that's right. So let's listen up, because that's where we are right now. So mom loses 2 kids in Ventura County, termination of parental rights. So she knows that she knows what the situation is, and she has her twins here in the good old state of California. She hops over the border to the Nevada-California border, hops over, and she specifically states that she is only going to in Nevada in order to have her twin babies and sign them over to her cousin. That's the only reason why she's there. Otherwise, she's a California resident, her home is here, her prior case is here, and so of course, when she has these babies in Nevada, the babies test positive. And Nevada social worker gets involved, and they file a petition on these babies. And then the question comes up while the children are in Nevada. They're born, they're placed with the maternal cousin, and they're living with maternal cousin. And for 2 months, the Nevada judge and the California judge continue to talk and have discussions. And Nevada finally makes a finding that mom only came over here to give birth to her babies, and that mom has no other real significant connection to Nevada. So the Nevada judge makes a finding that California is to take jurisdiction, and that Ventura County would agree to file a petition on these children. Now, the Nevada judge does not make any findings, okay? And parents in the appeal argued that the Nevada judge was wrong, and it was improper to decline jurisdiction, and that the judge didn't make any findings. Doesn't matter. The judge the jurisdiction doesn't, the home state jurisdiction doesn't even have to do anything, okay? I think there was one case that somebody had, I don't know if it was Bernadette or there was a case floating out there somewhere where literally there was no response from I think it was the government of Mexico or another country. And if there is no response, any act that is consistent with an intent not to exercise jurisdiction is tantamount to declining jurisdiction, and based on Enrage ER, that's what it is. That's what the law is on declining jurisdiction. So under Family Code section 3421A, I think 2, once a home state declines jurisdiction, California can properly assume jurisdiction. And another state can decline to exercise jurisdiction simply by being silent, because silence is tantamount to declining jurisdiction. So, and California can assert it. So, and you can go to Enrage ER for that language, because it's definitely in there. Let me see if I typed in. Yes, if a home state declines jurisdiction in any manner, conveying an intent not to exercise jurisdiction over a child, such refusal is tantamount to a declination of jurisdiction. So you don't, the juvenile court in Enrage ER did not make any findings, but the Court of Appeals said they don't have to necessarily make findings. Even if they were just silent, silence can be sufficient. So that is Enrage ER. And please keep that also in mind when you're making your arguments. And that's another inconvenient forum case, clearly, because all the information about mother, Ventura County knew more about this mother than Nevada did. Ventura County had already litigated her other children and made adjudication findings concerning them. So Nevada decided that it just makes sense to allow California to take jurisdiction. Now, if you are able to get a case removed from this court under that statute, just remember your client is not home free. It does say under 3427 subdivision C that California or any court who has home state jurisdiction, before you decline to exercise it, you must make a finding that you are only let me make sure that I state this correctly. It must be, one moment. The judge that has home state jurisdiction must only stay the proceedings on condition that the next state is going to file a petition and take jurisdiction. So that home state court cannot let the case go, but instead must stay the proceedings to give the next state time in order to file their petition. So if the proceedings are not completely dismissed, they are only stayed. So your client is never home free of dependency just because some other state is going to be stepping in and assuming jurisdiction. Just remember that. So you're really making the argument to find a place that's more convenient for your client. If your client is here and came here to have fun and thought they were going to live that LA life and is using drugs and doing what they need to do and brought their kid along for the ride, but everybody else is back home, then your job is just to get them back home to their family and to where the evidence is and to where they've got resources more so than what they would have here. It's not some kind of escape mechanism like they're never going to see the inside of a court again, no. Okay, and then back to Enrage Israel T. This is Judge Stanley Genzer, and it's Dependency 101, okay? Dependency 101, and basically the Judge Genzer, this is a drug case. Parents were caught selling drugs by the police. Dad flees and tries to run home to the house. When he gets there, mom comes out, gets the drugs out of a cup, out of the car, swallows them, and then both of them get arrested. Now, of course, parents came into dependency court, probably talked to their fabulous dependency parents attorney. Parents attorney said, you know, get your life right. And so they go and they enroll in parenting classes. They're going to all their visits. They're helping with all the care of the children. And by the time the jurisdiction hearing occurs, these parents are back on the straight and narrow. And so, of course, we make our standard argument. There's no further risk as of today because these parents look at them. How could they possibly have been swallowing drugs and fleeing from the police? So Judge Genzer hears the case. He buys the argument pretty much, and he strikes substantial from the petition and the word serious from the petition. So instead of it being substantial risk of serious physical harm, he makes it that they are at risk of physical harm. Not serious, not substantial. The Court of Appeal comes back and says, look, the language means what it says. The kids must be at substantial risk of serious physical harm. And if you don't have that magic language somewhere in the petition, then you don't have sufficient findings in order to for the court to take jurisdiction over these children. So then at disposition, Judge Genzer continues with his genius findings, and he goes, I don't see any kind of risk of harm to these children whatsoever. There's no evidence of abuse or neglect here. There's nothing. There's not enough. So you know what, parents, you go on and have a nice day, and you take your kids with you, and he returns the children. So the appellate court goes, what? So basically you didn't make the findings. You didn't make the findings you needed to make, and you returned the kids, and you basically made a speech. You gave a monologue about how these parents they pose no risk whatsoever. Okay, so that was dismissed because, of course, on appeal, the parents challenged that it's not about the sufficiency of the petition. That was not the issue here. The department pled the petition right, so this is not a demur issue. This is a Stanley Genzer judge, respectfully. Judge Stanley Genzer did not make the sufficient findings that he needed to make. It's that kind of issue. So you know how when we're sitting there in court and then the judge is rambling off all this stuff, they're reading their script, and then we can't hear what the judge is saying because that's when our parents are just like, no, that didn't happen. You know, and so I understand that it can be hard to actually listen to what the court is saying, but try your best to hear what the court is saying, and because it's not just a bunch of mumbo jumbo. They must make the findings that are sufficient to support the facts so that it stands up on appeal, or else they don't properly have jurisdiction. Now, one more note about this, and then I'll let it go. DCFS tried to pull that classic DCFS move and go, they said they argued, Well, you know, Your Honor, even though he didn't say the magic words, the record supports that jurisdiction was there. You know, there's drugs in little plastic baggies in the house, and it was within access of the children. So even though Judge Ginzer, you know, flubbed it, that you have the record before you, and you need to find that there's sufficient evidence based on what's in the record. And the Court of Appeals said, no, 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 not so fast. It's inappropriate for an appellate court to imply findings where the juvenile court failed to make express findings required by statute. So Stanley Ginzer needed to do his job, and he failed to do it, therefore reversed. Okay?
I'm Nichole. I'll wrap it up. I've got 5 cases, and the thing that I love the most about these 5 cases are that they are not from this district. All of the cases that are heard in Monterey Park are heard in the 2nd district. And the thing that's really, really fantastic about reading cases that are in the 1st, the 4th, the 3rd district is that you get to see dependency in a completely different way. So I'll segue. My first case, okay, so CA versus CP. So it's a family court case. This is not juvenile dependency. Nevertheless, it's really, really, really excellent for us because it gets into that common debate between presumed parents. The holding, we'll just cut to the chase and then I'll try to unravel it a little bit, is that if you've got a father who is presumed because he's the husband under Family Code Section 7540, he's conclusively the father. And then you've got the bio dad, yeah? He's the father because he opened his home and let the kid in and he held himself out. He's the rebuttable presumptive father. Those two go at it. And somehow, some way, we kind of get into this thing about, well, you know, the code says this, blah, blah, blah. Forget that. You guys know the code. And there will be cases where the code is, the details of the code is going to matter. But when you've got someone who's presumed under 7611D and somebody who's presumed under 7540, you're going at it. Substantive facts are going to have to go to, you have to go to trial. You've got to flesh it all out. So this is what happened. Mom was at work, she had an affair, she got pregnant, she didn't want anybody at work to know. She didn't tell her husband initially. Eventually it all comes out. The husband stays with her, and they decide to just do it as an open family. They're married, they're going to raise this baby. The biological father is also going to be involved, and they do this for 3 years. Wow. So not only does this child have these 3 parents, but this child also has the extended family of not only the husband, the mother, but the biological father. I mean, she's doing pretty well. They're doing good, and then something happens. It's not clear in the record, but something happens, and the bio dad, he wants to firm it all up. So he files his petition, all right? He files his petition in family court. He asks for 3 things. He asks for custody, not just the 3 years of, you know, whatever. He wants it in writing. He wants an order. He wants the name change because he thought that the daughter, the child, had his last name. But then he finds out one day, you know, she has her prescription bottle and he's giving her, because, you know, he does everything that the other 2 parents are doing. And it says, like, you know, Jane Smith, and his last name is Jones. So he wants the name change. And then he also asks for paternity testing. So he wants to firm this whole thing up. Once he files that petition, the husband and wife are like, you're done. You're done. Cuts him completely off. Cuts him completely off. Okay, so they go into court. The husband and the wife, they're raising 7540. He's the conclusively presumed father. We're married. We're stable. We want to, we further the policies in California of a stable marriage. Okay, but the bio dad, he's doing everything that the husband and wife are doing, and everything that you would expect a loving, caring, involved parent to do. So the facts are exchanged all over the place. So in the trial court, he wins. He wins. The husband and wife, they're not having it, so they file the appeal. So their entire appeal is about this whole thing about 75-40. And as actually, let me just one more thing. So this is 3rd Appellate District, Placer County. Okay, so the Court of Appeal parses through all of these fantastic, meaty facts about what this biological father is doing to raise this child, and it's pretty much, you know, a very clear-cut case. He's the dad. Okay, so there is no comparison, or there is no who should be the father, because we have what? Family Code Section 7612C. 7612C allows 2 persons, well, 3 people to be the parents of a child. And so if your facts happen to be 2 fathers who each have a right to presumed father status, perhaps one of the things you will pull out of your back pocket is a 7612C argument. And if you're going to do that, fact it up. Leave no fact uncovered, because that is how you're going to be able to get your parent, assuming you're the one representing the parent who's getting pushed out, to prevail. And that way you can have rights. So let me just read a little bit. So it says, the fact that a parent's claim to parentage arises from a conclusive statutory presumption and another parent's claim arises from a rebuttable statutory presumption does not change the fact that each man has a claim that arises under the family code. And this whole thing about protecting marriage, so again, there will be certain facts that will allow you and should probably encourage you to bring up the whole stability of marriage. But you guys remember, those statutes were written in a different time, with a different thinking, and we're here in the now, in 2019. So the Court of Appeals says, what constitutes a marriage and the scope of legislative authority over marriage has lately been the subject of significant changes. Okay, that's to say it, you know, lightly. Today, stable social compacts that differ from the traditional husband and wife combination are protected. So go in there with an open mind. If you are the one given a paternity contest, go in there with an open mind. Try not to go statute by statute. Try not to go policy by policy. Just get into the facts. Just break those facts out. Okay, moving on. Maria Curie. All right. Division, 4th Appellate District. This is San Diego. Okay, so here's how it goes. Okay, relative placement preferences. Okay, so 361.3. We all kind of immediately gravitate to that code section as the code section that you're using to litigate whether or not the child should be placed in a relative's home. Okay, Maria Q says 361.3 does not apply to relatives seeking foster care placement after a permanency hearing is held. So here's kind of, I'm going to tell you about just a little bit about the facts. So the girls and the boys, there's 4 children. The girls are placed together, the boys are placed together, but they're in separate homes. At some time before the mom loses her FR, okay, so we're not talking about detention. We're talking about after the reunification period has almost gotten to an end. An aunt identifies as a placement option. This is in May 2014. There's some, you know, back and forth about whether or not there was a follow-up by the agency. There kind of was, but in the end, the kids weren't placed with her. Jump to December 2014, okay, so May, June, July, August, September, October, November, December. December, FR is terminated. Oh no, so she comes forward in May, her home is, or she's sort of evaluated, but not really, it's kind of murky. No one follows up on it. December 2014, TFR. Okay, so then the 2-6 comes up, July 2016. So now we're 2 years later. Okay, and now we have the aunt May 2017, she says, oh, I want placement. So here she comes again. So first in May 2014, then again, May 2017, 3 years later, TFR has already happened. The 2-6 has already been heard. It got continued a couple times because why? These kids are really, really hard to keep in placement. They've got some issues. So she comes up twice. So then, after the kids are not placed with her, then she files a 388 asking for placement in August of 2017. So that's 3 years since she first came forward. There's a hearing on the request as to the girls, and this is why. The girls were in a placement where the foster care license for them wasn't really stable, so it wasn't clear whether or not this was going to be an adoptive placement for them. For the boys, it was summarily denied, so there wasn't even a hearing as to the boys because at the time of the hearing, even though these two sets of children, the boys in a foster care placement, the girls in a foster care placement, at the time of the hearing, the foster care parents of the boys said, oh, we want to adopt. So it became an adoptive placement. So the court wasn't going to even entertain that. Because this aunt was coming forward, she was not disclosing that she was going to adopt. She was just, I'm a relative, and I'm going to take these kids. And of course, behind the scenes, there's always this thought that if the kids are with a relative, the relative is not going to adopt, right? And so the parents will forever have parental rights. So at no point in time does she say this, right? So the hearing, okay, so after the hearing, the court denies the 388. Now, a couple of things. There was some procedural problems with filing the 388, or with the way that the court handled it. The court went back and forth with the parties about whether or not this was an Isabella G situation, right? Isabella G is that case where the relatives kept coming forward and kept getting refused, and it wasn't until after the parental rights had been terminated that the appeal happened. If I'm wrong, please give me. And then the Court of Appeals said, oh my goodness, we've got to reverse this whole thing because they had come forward at the very beginning and they were never, ever, ever given any kind of attention by the department. So this is different. This is different. So then eventually they settle on, oh, this is just a 361.3. Okay, so you're after the termination of reunification services. You cannot go by 361.3. You're filing a 388. You're filing a 388. The relative is asking for a post-permanency placement of a child. It's just like any other change in court order. So you're filing the 388. Then, to make the prima facie showing of changed circumstances, the relative must meet a threshold showing that she is fit and willing to permanently care for the child. If you meet that threshold, then you go into a hearing under 366.3D. So you can't revisit 361.3 except as a part of your hearing under 366.3D. When you go to that statute, it lays out all of these things that the court needs to do since the kids are now not in reunification. They are going towards a permanent plan. The court's whole view of what's happening with these kids is not the way it was before reunification. Right? You're after reunification, we're trying to get permanency, and so everything that the court's going to do, including changing the placement, including considering the relatives, is going to be from 366.26 on, including 366.3D. So everything that you guys are going to be doing when you've got these relatives who are coming forward, think about where you're at in the case. If you are beyond reunification, forget it. Don't just, oh, I just want a 361.3 hearing. You're done. You're done. You can't do that. 361.3 is relevant, but it's not the only thing that you're going to be using because you are now past reunification and the focus of the court is not on trying to reunify the kids with the parents or anything else. It's on permanency. Okay. So they did hint about 361.3 applying where a relative does not come forward to request placement until after reunification. They're not going to officially pass on that. So they just kind of left it there. I'm trying to see if I have any other notes. No notes. Okay, moving on. Termination of parental rights.
Nicole?
Yes.
However, post-termination of reunification, if by any chance the child is removed from wherever the child has been placed, doesn't SRV, this doesn't change SRV, that it sort of resets the 366.3 and allows for relative preference then to come forward, right?
I'm going to say this. If you are beyond reunification services, the court's views are going to change to just firming up the placement of the child for permanency. So I can't answer that question. I'm not going to be able to answer that question. Based on this case, you're done if the court terminates reunification services and then a relative pops up.
But if the placement, the whole issue is permanency. So if the child is in a placement that is no longer permanent, because let's say the prospective adoptive parent decides they don't want the kid anymore, the kid gets moved. SRV is very clear that relative placement pops back up. So
there's no.
So what do we ask for in that situation? We're waiting for the 2-6. There's an RPP, minors counsel gets notified that the kid's been moved, what do we do? Do we then argue SRV and say, here's the aunt who came late, but she's here, and now under SRV, you have to interview her and assess her?
So I'll say, whatever tools you're going to use them, because this case specifically said we're not passing on that issue. We're not going to resolve that issue. Whatever statute/case law you have available to you, and it is not inconsistent with Maria Q, go for it. So you're in that, I guess that in the way period, yeah, the gap. Okay. So so Enrage ET. So we have to love this case, but we're kind of scared that it might get depublished. This is the first appellate districts. This is like San Francisco and all the cases, all the counties up there. So this mom, she is like a typical situation where our client does not reunify, does everything that was asked of him or her in the case plan afterwards, then files that 388, does extremely well in doing so, and also maintains a fantastic relationship with the children. So at the 2-6, you're asking for not only the court to vacate its finding of terminating reunification services and return to custody, or maybe a subsequent period of FR, but also at that 2-6, assuming that you don't prevail, you're asking for your parent-child, your beneficial parent-child relationship exception to TPR. Okay, so this is this case. So this one is really special for two particular reasons. The first one is that, first of all, this mom wins, okay, but she wins on appeal. She loses at the trial court. Here, I'm just going to, kind of cut to the chase. There's two particular things about this case that are really relevant for trial attorneys. The first one is what Shannon touched on, and I'm so excited that Shannon raised the issue. You have got to listen to the findings. You cannot start doing something else. The findings are extremely significant, and in a case like this, where the facts were so unbelievably strong for this client, you really need to listen to the findings. So the second, just dovetail to the second reason why it's really great, because of the way this client is prepped. This client is the gold standard for our client who just could not do it during the reunification period and then turned it around and then just did excellently at the 388 hearing at the 2-6. So here's what eventually happened. Okay, so she has these, this is twins? I'm trying to see if this is the one with the twins. Yeah. Okay, so the twins, they were first removed in 2014. They were returned to her in 2015 with FM in place, so juris is still open. She relapses in 2017. They filed the 387. She gets no FR at the dispo. Okay. So you're thinking, oh man, it's over. In November of 2017, she files her 388. Because she's really working hard. She's got back in all her programs, and You know, she's visiting the children, and she's got a brand new life. So at the trial, everybody testifies. Everybody. She's got her individual counselor, the social worker, any and all professional persons that are involved, they're there. Then she testifies. When she testifies, she says things like this. I put a little. Here's what the court really, really thought was what did it for them. I didn't really flag it that well. Because there were so many wonderful things in this case, I guess I didn't flag it the best. Okay, in light, let's see, where is it? I'll just say that what they said was that she had such tremendous insight into what led the children to originally be removed from her. She testified so beautifully about what she took full responsibility, but she went above and beyond what our client, or what some of our clients do, which they, oh, it was my fault. She went to a place of just complete and total like enlightenment. And the Court of Appeal ate it all up. The trial court didn't. The trial court was like, oh, that's great. But it's the difference. It's the thing that made the difference on the appeal, okay? I don't know whether or not this district would have done what they did if the mom didn't testify as well as she did. So she did everything that she was supposed to do outside of court, but when she got into court, she articulated it beautifully. Okay, and then here's where this district was like, we're reversing. Because when the court gave its ruling, so right, the court is like, no, I'm denying your 388. I see changed circumstances, but I don't see that's in the best interest of the child. Okay, that's done. Then it goes into the 2-6 portion of it, and then he's going to make the findings that the exception doesn't apply. All right. The court concluded that mother's relationship with the children was not substantial enough to outweigh the children's need for stability. Sounds familiar, right? Oh, but he took it one step too far. He said that the children's bond to the mom was not to such an extent that they can't be happy in their current placement. Done. Court of Appeal, they jumped all over it. They said, that's not the standard. That's not the standard. So I wrote, phrasing is everything. The standard is, well, this is their version. The standard is whether the children benefit from the parent's presence in their lives, not whether they could eventually be happy without him or her. So listen to what the trial court is saying. There may be times where you want to say, I'm sorry, Your Honor, I didn't quite catch that. Did you say, and then you want to say the real standard, and then they'll parrot it, and then your record is beautiful. Or you may want to say it to kind of, get them to change their mind. However you want to play it, the ruling is really crucial, how they say it. Sometimes we're so relaxed that they kind of say a couple things and it sounds a little bit like what you're supposed to hear, and you're like, that's good. Okay? You really, if you have a case like this, you are really listening. And sometimes I remember I would just even lean forward to let them know, what do you say? And maybe even cup your ear. If you don't want to do that, just stay where you're at. I'm sorry, Your Honor, I didn't quite catch the findings. You said what again as to the beneficial parent-child relationship? What did you say again? Just to get them to, restate it or rephrase it. And then last but not least, so this case raises the Enrage EB. It's a case from 2010. The court cannot nevertheless terminate parental rights based upon an unenforceable expectation that the prospective adoptive parents will voluntarily permit future contact between the child and the bio parent. So I just want to bring that up. We do that a lot. Oh, they're the relative, and maybe the relative won't adopt. You can't do that. Don't do that. Don't get the court to buy into that. You got to have the right facts. If you have the right facts for the relative and they won't adopt, fine. But adoption is the permanent option. It's the preferred permanent option, or permanent plan. Okay, moving on.
Nichole, can I ask a really fast question?
Okay.
On Enrage EB, I mean, we wouldn't want to fix the court's ruling, though.
That's what I'm saying.
Right.
What are your facts? Who are you representing? whoever you're representing and whatever your facts are, you kind of make a decision if you're going to fix the fact or fix the ruling or not. Now, I always like the rulings to be clean. I want a fair fight. So even if fixing it up is going to make it so that my client doesn't get what we want, I still want the record to be clean. But it doesn't mean that every single solitary circumstance requires a fix-up. Okay, but just think about it, because if it does go up on appeal, they're going to run it the way the statute is written. So they're going to clean it up, whether you fix it up or not. So that's why I always end up just fixing it anyway, because that's what's going to happen on appeal. Okay, I have to kind of race through these next two. The two cases, Enrage Cody R and Enrage JY. Enrage Cody R, by the way, it got a brand new citation because it got modified in 2019. So right now it's not under 30 Cal Up 5th 381. Okay, so here's what happens. Something happens with the relative placement. Whether your client wanted it with that relative or your client never got that kid with that relative. You wait and you wait and you wait and you wait. You finally get to the 2-6 and the court TPRs. You file the NOA. You raise all these issues about placement. Court of Appeal is saying, don't do that. The only two issues at the 2-6 is whether or not the child is adoptable and whether or not any of those exceptions apply. You start raising issues about placement, and that's the first time you did it, they're not going to want to listen to that. A parent does not have standing to appeal placement orders from a judgment terminating parental rights unless, and this is going to be a huge unless, reversal of the placement order advances the parent's argument against termination of parental rights. You got to link it up. You got to link it up. So it is incumbent upon you as trial counsel. If there's a placement issue of any sort in your case, don't wait until the 2-6 to raise it. Raise it as soon as you possibly can. You can't get it wrapped up in the appeal assuming that your client gets her parental rights terminated. There's some other stuff about what this client did to try to get heard on review. She filed a writ. If you are interested in that, read the case and or come talk to me. We can talk all about it. It's really great language. Next is the Enrage JY. Same thing. This one is regarding an Indian child who was placed in actually there's two things. First, one of the placement of one of the children was changed and we're after the 2-6, after one of the first 2-6s. And then the other thing was, in these particular cases, if a child, sometimes there will be a tribal customary adoption order. And when that happens, the judge will at some point in time give that order full faith and credit. What happened was, subsequent to the first 2-6, not only was one of the children's placements replaced, but the tribe wanted to amend their order. And they amended it in a way that was really, really unfortunate for the mom, because at first she had these great visitation rights, and then she messed up on visitation, and so they had changed it, and they were like, no. They made it very, very restrictive. She filed the NOA after her parental rights were terminated, and again, they're like, well, no. The issue is adoptability and whether or not there's any exceptions. This whole thing about whether or not the tribal customary adoption order could be modified and the placement of this one child, you could have raised this a long time ago. You never, ever did. Don't come to us now after your parental rights have been terminated asking for us to now review all of these additional issues. So you as trial counsel, as soon as you hear any and all of these issues, raise them sooner, not later. Don't do this huge 2-6 trial and throw all of these different issues in there. I think I ran out of time.
Thank you.
Thank you.
Yes. Good job.
Thanks. You need a form? Yeah. Okay.